Hi everyone, my name is Alan Pryor, and I'm a Senior Associate in Alston & Bird's Litigation and Trial Practice Group. Today, I'd like to give a quick note about how federal courts are addressing personal jurisdiction with out-of-state, absent members in class action cases. Back in 2017, the Supreme Court handed down a decision in Bristol-Myers Squibb versus Superior Court, which barred courts in mass tort actions from asserting personal jurisdiction over plaintiffs with no connection to a defendant's activities in the forum state. Although some scholars believed that BMS had changed the class action landscape, many courts today still wrestle with whether they should even apply BMS to the class action sphere. So far, 3 federal appellate courts have responded with either an emphatic no, like the Seventh Circuit, or an inconclusive not yet, like the DC and Fifth Circuits. On one hand, the Seventh Circuit found that BMS simply did not apply to absent class members in federal class action cases. To the Seventh Circuit, if the named plaintiffs can demonstrate personal jurisdiction, that is enough to represent a nationwide class. On the other hand, the DC and Fifth Circuits did not squarely address the issue. Rather, the DC Circuit reasoned, and the Fifth Circuit suggested that these personal jurisdiction challenges are not ripe until after class certification. Or, so the argument goes, that is because putative class members are not parties to the action until after a class is certified. If these early appellate decisions are any indication, courts will maintain the status quo and deny early BMS challenges, even at the expense of practical case management considerations, with potentially walking back a certification order late in litigation, until the Supreme Court says otherwise. But even the Fifth and DC circuits haven't yet closed the door on BMS challenges. So at a minimum, remember to preserve your personal jurisdiction challenges in these kinds of cases.